Yes,
Yes,
sir.
very much, very much.
Yes, sir.
Clear,
Okay,
sir.
okay, absolutely audible, sir.
Okay,
Absolutely.
okay,
Please
okay,
continue.
okay. Good afternoon to all again. So
Good
I
afternoon.
welcome you all in this virtual session on future insolvency organized by ICSI IIP. I also at the outset I thank ICSI IIP for their invitation. I also thank you for your presence in this webinar. Friend, today our topic is cross-border insolvency. There is another subject, group insolvency. And I think it will be taken up in the next session tomorrow. So this cross-border insolvency, because you know that need for this, having the provisions for cross-border insolvency was well felt by the government of India long back. With the advent of liberalization or globalization, whatever you can say, what's happened, the business arena of Indian enterprises as well as the foreign enterprises I mean, they cross the respective territories. And as a result of which the assets and liability creditors of the enterprises, business enterprises or business entities, they are also now situated across the world, across the globe. So in case of any insolvency matter, how to deal with the assets or creditors which are lying beyond the territory of a country.
Yes, Adi bhai, कैसे हैं आप? आप
May I request you all to please mute yourself? So how to address this issue? This is the main objective for the cross-border insolvency. You know that when the first draft published by the BLRC, Bankruptcy Law Reform Committee, in the year 2015, they only prepared the draft based on the domestic insolvency. But when this draft was discussed before in the Joint Parliamentary Committee, JPC feels the need for inclusion of the provisions related to the cross-border insolvency also in the code. So as a result of which the two sections, section 234 and 235 were introduced in the code and approved by the Parliament. But again, I mean, though it is done, but I must say, and I think you will also appreciate, that not a very adequate provisions are made in the Insolvency and Bankruptcy Code of India. These are absolutely not sufficient to handle the cross-border insolvency issues. And as a result of which this subject till date is a subjective one. There are not much jurisprudence, not many jurisprudence, or you can say not many activities related to cross-border insolvency in the country, in our country. Whatever the cases we find related to cross-border insolvency, those cases are handled within the framework of IBC related to the domestic insolvency matters. But you know, the government of India is very keen to introduce your adequate provisions in the code, in Insolvency and Bankruptcy Code, to address appropriately the cross-border insolvency. And maybe in this winter session, we can find some new regulation, new law, new rules, regulations come into the picture in this coming ensuing winter session of the Parliament. So anyway, I have prepared a presentation. Let me share this presentation with you. Just a minute. Is it visible to you? Hello?
Yes.
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 Yes, sir, visible.
But it's affect my viewing.
Can you enlarge a little bit?
Enlarge a little bit. Just a minute. No, but it didn't go
Ah.
beyond my screen. Is it okay
No,
now?
but yeah, it's okay. It's okay, sir.
Okay, okay. So as I said that this is still now it is a subjective one. So I request all of you and not much to talk about it because still now it is in the provisions. It is within the code itself. I said that not many jurisprudence are there, not many instances are there handling cross-border insolvency in the country. So I request all of you kindly make it an interactive session. Please ask me the question whenever you feel like. Share your knowledge. If you have any knowledge, please share it. Please share your experience also if you have any, so that all of us can benefit through this discussion. So with this, I just start my presentation. So before I start, there are some disclaimers from my side that the opinion or the interpretation which is made here is purely my personal one and can be viewed or can be interpreted differently by others. And also in case of any legal requirement, I suggest you to consult your lawyer for this purpose. So friend, I have structured my discussion in this way. First of all, we will discuss about the introduction of Insolvency and Bankruptcy Code 2016 to have a better understanding of this subject. In under what scenario and why, which factors compel Government of India to introduce this Insolvency Code, that we will see. Then we will discuss the concept of cross-border insolvency, what and why. Also, we will discuss, we will see the economic survey which was made in the year 2021-2022 and budget 2022 on this cross-border insolvency matters. Then we will discuss these two sections. I said after the discussion of Joint Plan Committee, these two sections incorporated in the code for addressing the cross-border insolvency, that is section 234 and 235. We'll discuss these sections and we'll see what are the, I should not say a drawback, but definitely I will say the deficiencies. What are the deficiencies these sections have to address the cross-border insolvency appropriately within the, as required, as per the requirement of the case. Then I will discuss with you the issues arising from cross-border insolvency from Indian perspective. Also, we'll see the report of Cross-Border Insolvency Rules and Regulations Committee, CBIRC. I already told you that Government of India is very much keen to have an appropriate and detailed regulations on this cross-border. So they have appointed this committee and we'll see the what report they have submitted to the government to this aspect, in this respect. Then I will discuss with you two case laws. One is State Bank of India versus JTVRS India Limited. I am sure that all of you have heard about it. It is the only case law which handle the cross-border matter in this country, in India. And another is Stanbic Bank Ghana Limited versus Rajkumar Impacts Private Limited. It is also to some extent related to cross-border insolvency. But as I said, that till date it is handled based on the domestic regulations, domestic provisions of law, for insolvency. So we'll discuss these two cases. Then I'll keep say 15-20 minutes for your question answering section. But nonetheless, I request all of you, please ask questions, because you will appreciate that it will be easier for me to answer you along with my slide of presentation. Okay. So, friend, I know that I'm sure that all of you are aware that the Insolvency and Bankruptcy Code was introduced with effect from 1st December 2016 by making a publication in the official gazette. The code was introduced in Lok Sabha in December 2015 and got the presidential accent on May 2016. And the main purpose why this law was framed or is conceived by the government of India, the main purpose of Insolvency and Bankruptcy Code has been enacted as a code in India which seeks to consolidate the existing framework. I am coming to this. For insolvency resolution by creating a single law. Please mark this word, single law. Now, after the introduction of Insolvency and Bankruptcy Code 2016, it considers the only law which is concerns for all the insolvency matters in the country. And not only that, as a result of which it has become a one-stop solution for resolving insolvencies, which was a long process and does not offer an economically viable arrangement earlier. So, with the introduction of the code, Government of India is able to address this issue that now the act or law is economically viable. Why I'm saying so, I'll come to this. One thing here I really want to mention that I'm sure that you heard about the ease of doing business index published by the World Bank. This index shows the favored destination for the business enterprises across the globe. Which country they prefer to have their business. And the position of India has jumped significantly in this index. And friend, this is possible only because of the introduction for some new and very good business-friendly legislation by the government of India, like your GST and also this Insolvency and Bankruptcy Code, where not only the ease of doing not only the entry is, helpful, but this code also make the exit fast and less painful, I must say. It is a fact that not all the business enterprises gone into insolvency procedures for their own, only for the malified intention of the promoters. But there are some genuine reasons or cases also there. Like during COVID time, you know that all the, most of the entities in the hospitality sectors, hotels, travel agencies, they come under the insolvency process regime, because it is not their fault, because there is a ban in movement of the travelers or the tourists. So as a result of which they have come to that insolvency process. It is not their for their malified intention. So in such cases, the exit from the business is also made possible or made easier by the introduction of this Insolvency and Bankruptcy Code. Prior to Insolvency and Bankruptcy Code or IBC, there are several laws or acts to address the insolvency issues. Like I'm sure you heard about that Sikh Industrial Company Special Provisions Act, SICA, it is popularly known as, the Presidency Town Insolvency Act, then your Provincial Insolvency Act, Companies Act also, it addresses the winding up and liquidation procedures, Insolvency Act for the banks, etc., etc. But the main problem was all these laws or acts are independent to each other. They are not complementary to each other. And all of them address or handle different situations. Like SICA handles the insolvency matters related to the Sikh industrial companies. Presidential Town Insolvency Act, Provincial Insolvency, they handle the matter related to individual insolvency. Like Surface bank matters. You know, the main problem was that since these acts and laws are independent to each other and not complementary, it was very much possible for a person, for a litigant, when he finds that maybe the order will come against him or against his interest, it is possible for that litigant to file a petition, legal suit under the provisions or scope of other act. So as a result of which, what's happening? Getting the resolved position of the entity or the person becomes very, very time consuming matter. And as it is a time consuming matter, it also becomes a costly matter. So IBC was framed with the intention to expedite and simplify the process of insolvency and bankruptcy proceedings in India. It strives to protect the interest of stakeholders and make the process of doing business an efficient task. I already told you that the intention of Government of India to introduce this code to make a single law within the country to address the insolvency issues. So all these things, I mean, whether it is Sikh company, whether it is individual, whether it is bank related matter, all are come under and addressed through this insolvency and bankruptcy code. It is now become a single law. And as a result of which, it provides a strong insolvency framework. You will appreciate that since it is the single law, that earlier scope that they shift their petition legal suit to other act, it is not possible, absolutely not. So it becomes, it provides a strong insolvency framework, and whereas the cost and time incurred is minimized in attaining the liquidation, or you can say resolution. So friend, I am sure that you appreciate the intention of Government of India for introducing this code. Now, if we see the objective of IBC, which is provided in the preamble section of the code, it says that IBC is an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, individuals, all it is included, in a time-bound manner for maximization of value of assets of such person, to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders. So the intention again very much clear from the objective which is mentioned at the beginning preamble of the code, that it is to be a cost effective, maximization value of assets, and balance the interest of all the stakeholders. That means it is also within the time. The loss of time can be minimized through the introduction of this. And as a result of this objective provides some unique proposition to IBC. First of all is a consolidated law, and friend, for this purpose, this IBC, the provisions of IBC is also very much appropriate or required for addressing the cross-border insolvency. Because Government of India has framed this law only to address the insolvency proceedings. So be it domestic or beyond the country's jurisdiction. So we must have an appropriate provision in the code itself to address our cross-border issues. As it is a consolidated law now, it is a single law now. Time-bound process, yes, because I'm sure you know that there is section in IBC which categorically specifies the days by which the process to be completed. Maximization of asset value. This is also another objectives of IBC, which requires a detailed provision for your cross-border insolvency procedures. Because as I said that due to the liberalization or globalization of the country, the business enterprises have spread across the globe, not only Indian economy. Other enterprises from the other countries also, they started doing business in India. And the asset and creditors, liability, everything is now, you can find for a business entity across the globe. So unless and until you have the control over the assets of the corporate debtor, which are lying beyond the territory of our country, maximization of asset value is not possible. And as a result of which you require the provisions in the law, in the act, how to get those assets which are lying beyond the country's territory into your book, or you can deal with them. If you are able to handle those assets, then only you will be able to maximize the value for the corporate debtor. And you all know that this maximization value of corporate is very much essential to have a better resolution plan for them. IBC, the main objective of IBC is to have the first to revive the company, and that can only be possible through an appropriate resolution plan for the corporate debtor. They need promote entrepreneurship, yes, of course, because I said that the main intention of the IBC is to revive the company, and through this process it invites the new entrepreneur and promote the entrepreneurship. Credit availability, it releases the stuck-up fund in the books of the corporate debtor and the financial institutions, get the money back, and they have the credit availability in their books. And balancing interest of all, whether they are the operational financial creditor, operational creditor, even the shareholders of the corporate debtors, all interests are addressed. Workers, employees, all interests are addressed through this IBC, and these give some unique propositions to the code. So now we'll discuss the concept of cross-border insolvency. If you have any questions so far, you please ask me, because what we discussed is in general for the code, and what is the requirement to have the proper provisions within the code to address the cross-border insolvency. Now we come to the subject itself. What is cross-border insolvency and why it is required? Cross-border insolvency situation arises when the debtor has assets or creditors, both assets or creditors, in more than one nation, or when different insolvency proceedings have been filed in multiple jurisdictions. So the situation which gives rise to this cross-border insolvency, firstly, the corporate debtor should have the assets more than one territory, one country, or maybe the creditors for that corporate are also situated in more than one country, or maybe some judicial proceedings are continuing against the corporate debtor in more than one country. In that case also, you require the provisions, how to handle these things. Suppose some corporate debtor has come into the CIRP process in India, in our country. At the same time, someone also filed an insolvency suit against that corporate debtor in other country. So how to liaison between these two? How
Sir,
to ensure? Sorry,
may I,
hello?
may I have a question?
Yes, tell me please.
Sir, the jurisdiction part is very, very important to understand. Suppose somebody gets the decree in Ghana, you can say this South Africa, wherever actually, and that creditor comes to India and file a petition under Section 7 on the basis of default, some creditor, financial creditor. So now the thing is, there should be some agreement with the concerned country under Section 234 and 235, whatever these sections actually they speak about the cross-border insolvency.
Right.
So the jurisdiction point, we want to understand how to go for it. Suppose some land is situated in, the IRP been appointed, corporate debtor land is situated in somewhere in another country. So those laws are applicable. So, I mean, they are very difficult to implement those things. That actually part we want to understand. So how to execute such, the decrees, such and a court orders, how to implement those orders. That is the main thing, actually, we want to understand.
Yeah, it's a good question. And you know exactly what the situation you now saying is in our second case law, Stanbic Bank of Ghana. So we'll discuss it. We'll discuss it.
Okay.
And how that is the you know again and again I'm telling you this 234 and 230 is not the sufficient one.
Correct.
Absolutely not sufficient one. That's why I'm saying that government of India is keen to introduce more. And ancestral role is the mother. I mean, whenever you ask that other country to follow your insolvency code, they'll see, they'll check that whether it is as per that model law or no. If it is not done, and again, but at the same time, you have to keep in your mind that not all the provisions of model law are applicable in India. That is also another issue here.
Correct.
That is
why. Sir, it is very, very difficult. Yeah. Very difficult in the sense, suppose, okay, foreign country decree comes here in India, right? We can implement because we can seek the help of the courts and whatever things comes. Because in that case, actually, it had happened and we understood the things.
Yes.
The main thing is the corporate debtor whose property is situated abroad, outside India.
Yes.
Now, administrator should be appointed to protect the property.
Right.
So how to take the possession of that particular property?
I would request you just wait for some time. Maybe I will address these things now. But I request you please note it down because these things will, if I don't address this through my presentation, we will have a detailed discussion during question and answer session.
Sure, sir. Sure.
And I request all of you, because again I'm saying this very subject. I am also not very much knowledgeable on this. Sir. Because there is a lack of jurisprudence or lack of case laws. I am also not very much aware of this, how to handle it. But what you said is absolutely important, and Government of India is very keen to have it, because this is the ultimate. You cannot, at the same time, you cannot get rid of it also,
Correct.
because now it is a globalization era.
Yes.
So definitely some and there are the parties, data like corporate debtors, who have the assets situated in other countries.
Of course.
So this is very important thing. Thank you. So the cross-border insolvency situation arises when the border debtor has assets or creditors in more than one nation, or when different insolvency proceedings have been filed in multiple jurisdictions. What is Mr. Khetri, your name? Khetri just now mentioned.
Sundar Khatri, sir. Name is mentioned, sir. Sundar
Yeah.
Khatri.
Sundar Khetri, yeah. Just you have mentioned that what's happened to that. But if it so happens, you cannot have the resolution. I will not use the word solution, but I definitely use the word resolution through this present insolvency law, which
Yes.
is, I said that BLRC, first prepare the draft based on the domestic insolvency, and since the JPC said no, some element of cross-border should also be there, they have introduced two sections, section 234 and 235, which are absolutely not sufficient.
Correct. Absolutely, I agree to this.
Thank you. The cross-border insolvency mechanism is primarily focused towards regulating the insolvency proceedings that operate much beyond the ambit of domestic jurisdiction. It is not like your domestic jurisdiction, it's much beyond that. Cross-border insolvency is also termed as international insolvency. Since the more than one country is involved, it is also termed as international insolvency. And in order to have an appropriate provisions in the code, you must, what he said, that the ancestral law, it is called model law, you have to take cognizance of the provisions of the laws and acts of that country also. Otherwise, the entire thing will be jeopardized. They will say that we will not abide by with your provisions. It governs the fate of debtors having multinations, assets and creditors. Yes, we have already discussed, or jurisdiction. The importance of cross-border insolvency lies in the fact that business today involve an international and cross-border element, and therefore the effects of cross-border insolvency cannot be ignored for too long. And in my subsequent slide, I have discussed that when this economic survey was presented, Government of India has realized these things and also put in the document, in the discussion paper, about the introduction of the cross-border insolvency. Investors invest in an entity having cross-border elements in its transactions, and when that entity goes into insolvency, both domestic as well as international investor would seek to protect their interests, and as such, and at such time, cross-border insolvency principles play a vital role. It is not only the asset friends. It also happened that I as a business entrepreneur, get the loan or get the fund from the foreign institutions also. So if I goes into the insolvency procedures, that the investor which situated in a foreign country or foreign land, definitely they will try to protect themselves by through recovery of their money. So for that purpose also, this cross-border insolvency plays a very vital role. You must have the appropriate provisions therein. Insolvency and Bankruptcy Code 2016 provided mechanism for creditors of an entity to initiate corporate insolvency resolution process, or CIRP in short, in the event of default in payment of debts by the corporate debtor. However, the code does not provide for an effective mechanism to deal with the cross-border insolvency proceedings. You know what's happened in India? Okay, fine. If a corporate debtor or a debtor principal borrower fails to pay his money which he has borrowed from the financial institution can file the case or petition under section 7 to NCLT. Understood. But what's happened if Indian financial institution, they lend money to a foreign company? It can happen. Now it is open. I mean, after a certain limit, it requires RBI approval. RBI gives approval also in the appropriate cases or in the proper cases. But if the company goes into liquidation in that country, how the Indian financial institution, they will safeguard unless and until there is proper provision in the cross-border insolvency. So for all these reasons, we require the appropriate provisions for cross-border insolvency. What I am telling you, Economic Survey 21 and Budget 2022. I'm sure all of you are aware that before the presentation of budget for a particular financial year, the Government of India also published and present, I think the day before the budget presentation, they prepare and present the economic survey for the last financial year. And it guided as a principle to set the budget for the next financial year. So if we see the economic survey for 2021, this economic survey had called for a standardized framework for cross-border insolvency, as the code at present does not have a standard instrument to restructure the firms involving cross-border jurisdiction. It is in the economic survey in the year 2020, 21, 22, and now we are operating in 24-25 financial year. Till now, this situation exists. Hopefully, this winter session, something will come. The survey pointed out that presently the code provides for the domestic laws for the handling of an insolvent entity, but not to restructure the firms involving cross-border jurisdictions. It is only the code, the survey itself admits that the till date, I mean, the code is for the domestic insolvency, not the cross-border insolvency. The survey noted that the problem of not having a cross-border framework was also expressed by the National Company Law Tribunal while adjudicating a cross-border insolvency case involving an Indian entity where the insolvency proceedings against the corporate debtor were already initiated before a foreign district court. Just now, Mr. Khetri raised this point. And this is, I'm telling you, we have the case law, we'll discuss it in detail, but this is this observation was made by NCLT Mumbai in the case of State Bank of India versus Jet Airways. When the Netherlands Dutch administrator filed the petition before the NCLT Mumbai, they agreed that there is a proceedings going on, but in absence of any provisions, they cannot take cognizance of that thing. But okay, we'll discuss it later. So survey also mentioned it, that NCLT has already raised this point for the need of a detailed provisions for cross-border insolvency. It was noted by the tribunal that since there is no provision and mechanism in the code to recognize the judgment of a foreign insolvency court, the tribunal could not take the order passed by the foreign court on record, even though it was verified and found to be correct. They cannot, they say that we cannot take on record means they cannot mention it in their order also. They look, there is an order, but at the same time they are sure that it is a correct one. This document, the application which is filed by the Dutch administrator is a correct one. So you can understand the problem. And this is also revealed by the economic survey of Government of India. The survey said that the absence of a cross-border insolvency framework creates complexities and raises various issues, such as extent to which an insolvency professional may obtain access to assets held in a foreign company. I mean, it is clear to all of you, the observation of the economic survey. It is further said that other issue is priority of payment. That is whether the local creditors will have the access to local assets before the funds to the foreign insolvency administrator. Similarly, the recognition of claims of local creditors by the foreign insolvency administrator is another issue. I am sure that you all of you are aware of that section 53 provisions, which talks about the waterfall mechanism. But friend, there is no provision in the code to see or to decide whether this waterfall mechanism will also applicable for the foreign creditors. Because you know what's happened, these assets, some assets of the corporate are located in India. They are the Indian assets. So for the Indian assets also, the foreign creditors will get the priority or not. There is no provision in the code. And similarly, and vice versa also. Some assets of the corporator are lying in the foreign land for which insolvency petition is going on. And if it is settled, whether this local creditors will have the priority or will get the priority as per their law on the assets of this corporate. So all these things jeopardize the entire process, resolution, insolvency resolution process. Another issue related to recognition and enforcement of local securities taxation system over local assets where a foreign insolvency administrator is appointed. So these are the issues the economic survey is mentioning. Presently, while foreign creditors can make claims against the domestic entity under the provisions of the code does not allow automatic recognition of any insolvency proceedings in other countries. You ask this question, so it is answered here. Foreign creditors are allowed to make claim under for against domestic entity under provision of code, but there is no provision in the code that there will be an automatic recognition of the decree or order insolvency proceedings in other countries. So again, the things become jeopardy. Therefore, the survey emphasized on framing out cross-border insolvency provisions by saying that it can be seen that current provisions of code are ad hoc in nature and are susceptible to delay. entering into mutual stroke reciprocal agreements require individual long-drawn negotiations with each country. This leads to uncertainty of outcome of claims for creditors, debtors, and stakeholders as well. So the survey said that in absence of, at present, which is now going on, if in absence of any detailed provisions within the code to address the cross-border insolvency process, if it is done through an ad hoc basis on mutual or reciprocal agreements, it will be a long run process. The time for which the IBC was introduced with the objective to a time-bound manner, resolution in a time-bound manner, that will be surely be defeated. And also it leads to uncertainty whether this mutual reciprocal will mature, whether the other country will agree. There is no certainty about it. And definitely this will not, this will be against the benefit interest of all the stakeholders. No doubt about it. The survey serves as a policy guide. I already told you that the survey paper submitted by the government before the budget presentation, and it serves as a policy guide, how the government is going to address the scenario, economic scenario in the forthcoming budget. In line with the survey, the Honorable Finance Minister, while presenting the budget 2022, said that necessary amendments will be made in the Insolvency and Bankruptcy Code for more efficient and quicker dispute resolution and to enable seamless cross-border insolvency resolution. But friend, unfortunately, this has not yet been done. Lots of discussion was going on. I think lots of attempts also made by the Ministry of Finance, but till date it is not done. Again, I am saying at the cost of repetition, maybe we see some light in this current winter session. But no doubt this is very, very much required, because the reason for which our country, India, has jumped in the ease of doing business, definitely unless and until we address this cross-border insolvency issues, according to me, as per me, maybe we'll lose that position. Okay. Adoption of cross-border insolvency framework is a welcome announcement in the budget 2022. In the present economic scenario, world supply chains stretched across geographies and assets can be moved from and dissipate across jurisdictions. Now we have already discussed this. Access to foreign courts, recognition of proceedings therein, subsequent grant of relief to protect assets of debtor or interest of creditors, communication and coordination among jurisdiction will facilitate successful resolution of the cross-border cases. So, in order to have a proper legislation for addressing the cross-border insolvency, the provisions must acknowledge and must have the guidelines or the procedures to protect the assets of the debtors and interest of creditors. Protect the assets of the debtors which are lying across the globe, and the protect of the interest of creditors who are situated in different countries of the world. Coordination among the jurisdiction. Definitely this is an, I mean, what should I say, a very burning issue, that the recognition of the judgment, the recognition of the order, or the coordination between the functioning of the courts. Suppose the two insolvency processes operating parallel in two different countries, in our country, in another country. How to make synchronizing of the orders passed by both the countries. That is also very important. And you must have the proper jurisdiction, I mean, provisions of law for that. This is required for the successful resolution of cross-border insolvencies. So now we move to the section 234 and 235, which are currently in the code. And I will also discuss with you what are the limitations we have. We have the position, but there are certain limitations, not certain, there are limitations, very great limitations in this section, in these two sections, to address the cross-border insolvency. But before I start, if you have any question, please ask me. Do you have anything in chat box? I don't. So now first we just a minute. Anything in chat box? Just a minute. How much of the federal detail? Just a minute. Mr. Sharma said that recently I was engaged as RP in a group insolvency real estate matter presently under stay by I got an opposite to publish 3 forms. One. Mr. Sharma, I'll request you that kindly share your this experience in our question answer session, okay? Because the following point needs to be clarified. Claims to be collected and verified. Ms. I request you that you please raise this point, the question and such, we will discuss in detail, okay? So friend, this section 234, this talks about that agreements with foreign countries. It mentioned that the central government may enter into an agreement with the government of any country outside India for enforcing the provisions of this code. So it says that, that there should be an agreement with the government of India for the enforcement of this provision of this code for addressing the cross-border insolvency. The central government may, by notification in the official gazette, direct that the application of provisions of this code in relation to assets or properties of corporate debtor or debtor, including a personal guarantor of a corporate debtor, as the case may be, situated at any place in a country outside India with which reciprocal arrangements have been made shall be subject to such conditions as may be specified. So section 234 says, I am audible. I think I am audible. Hello?
Yes, sir, you are audible.
I am audible. No? So section 234 said that in order to address the cross-border insolvency, firstly, the government of India will enter into an agreement with the government of the other country, and then they, by a notification in the official gazette, direct that application of the provision of the code for those countries situated in any place of the country in which the reciprocal arrangements have been made. And subject to such condition, for elsewhere, you know that when a reciprocal arrangement is made, there are certain terms and conditions, and subject to that terms and conditions, this cross-border insolvency matters will be addressed. And what does section 235 says? Section 235 is talk about a letter of request to a country outside India in certain cases. Notwithstanding anything contained in this code or any law for the timing in force, if in the course of insolvency resolution process or liquidation or bankruptcy proceedings, as the case may be, under this code, the resolution professional, liquidator, or bankruptcy trustee, as the case may be, is of the opinion that assets of the corporate debtor or debtor, including a personal guarantor of a corporate debtor, are situated in a country outside India with which reciprocal arrangements have been made under section 234, he may make an application to the adjudicating authority that evidence or action relating to such assets is required. In connection, evidence or action relating to such asset is required in connection with such process or proceedings. So first, it is said, this particular section said that resolution professional, liquidator, or bankruptcy trustee first ensure that there is an corresponding agreement with that country where the asset is lying. And if it is so, if there is any reciprocal arrangements, then the insolvency professional or liquidator or bankruptcy trustee will file an application before NCLT to have to authority that the evidence or action related to such assets is required in connection with the process or proceeding. And then only it can be done. And the adjudicating authority on receipt of an application under subsection 1 and on being satisfied, please mark this word, on being satisfied that evidence or action relating to assets under subsection 1 is required in connection with insolvency resolution process or liquidation or bankruptcy proceedings, may issue a letter of request to a court or an authority of such country competent to deal with such request. So friend, I am sure that we have seen, we can visualize the deficiencies which are there in under section 234 and section 235. Again, at the cost of repetition, I must say that section 234 says that firstly, the government of India has to enter into a reciprocal arrangements with the foreign country, foreign government. And then it will be notified in the Gazette and subject to the terms and conditions of that arrangement or agreement, the cross-border insolvency cases will be handled. What's about the time frame? There is no time frame mentioned. What's about the terms and conditions? If these terms and conditions are in violation of the provisions of the insolvency code, whether section 238 will be applicable? I don't think so. Now you consider this section 235. It said that if there is a reciprocal arrangement, assuming there is a reciprocal arrangement and it is in, as per the code, then the resolution professional or liquidator or bankruptcy trustee, they first of all, they have to ensure and they have to make sure that there is an arrangement, and then they file an application before NCLT for a necessary letter of request. And NCLT, if it is satisfied, friend, it is again a subjective matter. It is not an automatic, or it is not as per the provision of the law. You have to satisfy the NCLT that they will issue a letter to the other competent court or competent court of the other country, and they will issue the letter, may issue a letter, request to the court and or an authority of such country competent deal with the matter. What's happened if they refuse it? You have made a request and they say no, you don't agree. So can you operate? Can you have the proper insolvency resolution with the help of these two sections? Nonetheless, there are something, what should say that there is something in the provision, but absolutely not adequate, not workable. Bilateral agreements are only allowed under section 234 for the purpose of enforcing the provisions of the code and not for any other issues arising in cross-border insolvency process, namely access to the official. Yeah, this is also very important. Access to the office holder appointed in foreign proceedings to participate in proceedings under the code, recognition of foreign insolvency proceedings, etc. So, this 234 says there will be a bilateral agreement, but bilateral agreement will be for the observance of the provisions of the code, enforcing the provisions of the code. But the section 234 totally silent on the accessibility to the office holder. Suppose other country also appoint an IRP for the insolvency process of the same corporate debtor. So whether the IRP or IP of Indian IP or IRP can have an access to the office of the other IRP or IP of that other country, or whether the IP or IRP of India can he participate in the proceedings of under the code of the other country. If any order is passed by the foreign insolvency court, whether that order will be admitted by the court of by the adjudicating authority in India. All these things are totally silent under section 234. It only says that okay, some reciprocal arrangement or agreement will be made to enforce the provisions of the code. Similarly, for section 235, it is mentioned that adjudicating authority is empowered under section 235 to issue letter to the extent of applicability of code in respect of assets or property of corporate debtor or personal guarantor situated outside India. The experience of India in the matters of reciprocal arrangement is not encouraging. In cases of recognition of foreign judgments and proceedings under section 13 of section 44A of CPC, Code of Civil Procedures, deal with the execution of decrees passed by courts in reciprocating territories took years to obtain recognition. The only section 13 of under section 13 and section 44A of Civil Code, they recognize the foreign judgment, and that too only in respect of reciprocating territories, which takes the number of years to settle. And for your information, I may read out the countries till date, the countries for with whom we have the such reciprocating arrangement. These countries are United Kingdom, Eden, Fiji, Republic of Singapore, Federation of Malaysia, Trinidad and Tobago, New Zealand, the Cook Island, including New and the Trust Territories of Western Samoa, Hong Kong, Papua and New Guinea, Bangladesh, and United Arab Emirates, UAE. The major investors in India, that is USA, and also many European countries are not in this list. We don't have any reciprocating till date. We don't have any reciprocating arrangement. So it is said the experience of India in the matter of reciprocity is not very encouraging. So what 234 suggests, that you get a reciprocal arrangement, maybe that is not a very feasible solution. Negotiating multiple agreements will be time consuming and costly, as it will involve multiple ministries and many stakeholders in negotiating countries. Also, there will be many uncertainties, and according to me, not only the multiple ministries or stakeholders in negotiating countries, but also within the country. We have the Minister of Finance, we have the Minister of Commerce, we have the Minister of Corporate Affairs, we have the Home Ministry, we have the External Affairs Ministry. So when you go for such reciprocal arrangements, all this, you have to take the consent or at least the observation from all these ministries. You can imagine, you can imagine the time factor, the time which will be required to have such reciprocal arrangement. Apart from the ministerial, hurdle in the other side. I don't know what are the hurdles they have. And that's why it is said is too much uncertain whether we will have this arrangement or not. The agreements will eventually have to be in line, and definitely what I told, that whenever you go with them for an arrangement, they will see, because that model law or the ancestral law is the Bible for across the globe. They will see that whether this model law has been followed or not. If there is any deviation in your code with this model law, definitely they will not agree to sign the agreement with you. So these are the deficiencies we have. Though we have some provisions in the code, but friend, according to me, I feel these are absolutely not sufficient to address the cross-border insolvency. And that's why I personally believe this the subject matter of today's discussion is very, very much appreciated. Future of insolvency. If you have a real solid insolvency law in your country, you must address the issues related to the cross-border insolvency. Now we'll discuss the issues arising in cross-border insolvency proceedings from Indian perspective. What issues we face in this country? The discussion which I have made with you now is the deficiency of section 234 and 235, and out of which what are the deficiencies till now we have faced. The existing provisions in the code, that is section 234 and 235, do not provide a comprehensive framework for cross-border insolvency matters. The Insolvency Law Committee recommended to provide a comprehensive framework for this purpose based on ancestral model law on cross-border insolvency 1997 by making a separate part in the code after certain modifications in it necessary in the Indian context. We'll discuss the report. I'm sure that you know that IBC code is divided into 5 parts and consisting of 282 sections and 12 annexures. So what recommendation this Insolvency Law Committee has made? They made that to frame a appropriate legislation towards cross-border insolvency based on ancestral model law on cross-border insolvency 1997 by making some modifications, because I said that not all provisions of this model law are applicable, can be applied in Indian context. So they also realized this thing. They say made some modifications there, and most importantly, they said that you make a separate part. Don't club it with the part which deals with the corporate insolvency process. So they recommended that there should be a separate part for handling for the provisions of cross-border insolvency. And in their report, they have mentioned the part Z. They have not mentioned it will be part 6 or that like that. Maybe the government of India say it will be part 2A. Acceptable. But it should be provided as a separate part in the code after certain modification in the model law. Further, as part 3 of the code, which deals with insolvency resolution and bankruptcy for individual and partnership firms, has not been notified, the application of cross-border insolvency proceeding provisions to corporate debtor and LLPs also. That also they have recommended that you must not include the individual or partner, but definitely they said that you can include the corporate debtor, guarantor, or individual guarantor to the corporate debtor. That's why the bankruptcy trustee also they have mentioned. So they said that this LLP and corporate entity should be incorporated under the cross-border insolvency, since part 3 is yet to be announced. Sections 234 and 235 of the code, which envisages entering into bilateral agreements and issuance of letters of request to foreign courts by the adjudicating authority, resulted in an ad hoc framework, and that was susceptible to delay and uncertainty for creditors and debtors as well as for courts. This is observation made by the Insolvency Law Committee. They said that this provision is made on an ad hoc basis. I also told you, BRHC initially recommended for the domestic insolvency. When Joint Parliamentary Committee said no, there should be a provision for the cross-border insolvency too, then these two sections was incorporated. But they said it is made an ad hoc framework, and which will lead to delay and uncertainty. We have already discussed these points. The mechanism for enforcement of foreign judgments under CPC 1908 is not broad enough to include all insolvency orders, namely orders regarding reorganization process, administrative and interim orders, etc., rendering many judgments and orders in the insolvency process unenforceable in India. So now we'll discuss the report of Cross-Border Insolvency Rules and Regulation Committee. In short, it is called CBIRC. And you know that I told you also that Government of India is very keen to have this a proper cross-border insolvency provisions in place. So they have appointed this committee, Cross-Border Insolvency Rules and Regulation Committee. But before I start discussing their report, if you have any question or you require any clarification, any elaboration on the discussion which I have made so far. Hello, I am audible, I believe.
Sir, very much audible.
Acha, any question you have? No. Okay. Then I move to my next part of my presentation. This is report of Cross-Border Insolvency Rules and Regulations Committee, CBIRC. The Cross-Border Insolvency Rules and Regulation Committee submitted its report during June 2020. The same was released by IBBI in November 2021. They published this report on 2020 and IBBI released this report on November 2021. Sorry. The report specifies the following issues of cross-border actions that are likely to arise for various case types for Indian and foreign companies. So they jotted down the issues which may arise, and also they have suggested, they have recommended for resolving these issues. They said that how government should take care of to resolve these issues. Firstly, they said the recognition of Indian proceedings by foreign courts. So they said if any insolvency resolution process is carrying on under the Indian court and a similar insolvency process is also undertaken in the foreign court, they said as one of the issues how the Indian proceedings will be recognized. They didn't say that, okay, as per the agreement, mutual agreement. No, they said we have to find out that. The recognition of foreign proceedings by adjudicating authority in India, vice versa. If something is going on there, here also an insolvency proceeding is going on, how the order passed by the foreign court will be recognized. by the adjudicating authority, that is NCLT in India. Designation a proceeding as main proceeding or non-main proceedings. It is very, very important for cross-border proceedings. I'll go for some detailed discussion later. But in short, you know, when a proceeding is filed, suppose the corporate debtor, they mainly incorporated in India and mainly have business in India, but also have branch offices or place of business in other country. Now, if some insolvency matters are raised in the other country, whether that will be considered as the main proceeding, or since the main place of business of that corporate debtor is in this country, India, that will be considered as a non-main proceedings for that particular corporate debtor. Am I clear? Main proceedings are the proceedings for which the numbering also, non-mention also numbering are made, but main proceedings are conducted based on the rules or regulations of that country. Whereas non-main proceedings also conducted, but they are the subordinate to main proceedings. If you take the example of JTRS, the main proceedings is India, because JTRS is registered in India and having the main business of operation in India only. But the proceedings, liquidation proceedings is in Amsterdam, in Netherlands. That is considered as a non-main proceedings. That is also a resolution proceedings, but that is considered as a non-main proceedings since the business is the company is registered in India and main business is conducted in India. Am I clear? I mean, if you have any doubt, you please ask me. So CBIRC also raised this point that how this demarcation will be done on main proceedings or non-main proceedings, between main proceedings and non-main proceedings. Grant of access to foreign representative to act in respect of foreign proceedings and to participate in proceedings in India. A grant of access to foreign representative to act in respect of foreign proceedings and to participate in proceedings in India. So how the foreign representative or the foreign administrator will be grant permission or access to participate in Indian proceedings. That also they said that it is also an issue to be addressed. Similarly, grant of access to Indian IPs to act in respect of Indian proceedings and to participate in proceedings in foreign jurisdiction, vice versa. So unless and until both of them are given the permission or access to participate in the corresponding jurisdiction, you can understand we don't have the, I mean, proper or real resolution, insolvency resolution. That is the main theme, main idea of cross-border insolvency. Grant of access of Indian creditors in respect of foreign proceedings. IBC allows foreign creditors access to Indian insolvency proceedings, and the same is not automatic for Indian creditors. Right? This is a very, very vital point. Presently, we have in our insolvency code. A foreign creditor can file his application in Indian court but it is not vice versa, an Indian creditor. But since due to this globalization, everything is now open. Everything is now level playing field. Indian financial institutions also have a solid investment in foreign countries. But till that they cannot file application. It is not an automatic way. There are certain provisions, certain procedures, I might rather say, to file the applications. Special vehicles, purpose vehicles, all these things. Then cooperation between foreign court and NCLT. NCLT and foreign representatives, foreign court and Indian IPs, Indian IP and foreign representative. Unless this cooperation is ensured, I'm sure that you will agree with me that there will be no proper cross-border insolvency resolution. Coordination between domestic and foreign proceedings for an Indian company. Coordination between one domestic and Indian proceeding and another foreign proceeding for a foreign company. So you understand, no? I mean, Indian domestic proceeding and foreign proceeding for Indian company, both the proceeding is going on in both the country, and for the foreign company, domestic and Indian proceeding, the case is filed here. These Indian proceedings and another foreign proceedings. Some case against that foreign company also filed in that country, in his country. So how the cooperation or coordination between these two will be maintained? So this is the suggestion. CBIRC suggested the applicability of cross-border framework should not include Indian FSP, financial service providers, as per section 227 of the code. I'm sure you are aware that as per this section, IBC, Insolvency and Bankruptcy Code, is not applicable for a financial service provider. NBFCs are outside the purview of IBC, Insolvency and Bankruptcy Code. It is suggested that provisions of the code should be made applicable to foreign LLPs and foreign companies having an establishment in India. So they said that it should be applicable. The provision of the code should be applicable for the foreign companies and the LLPs having place of business in India. It is suggested, what I told you already, that main and non-main proceedings will be determined based on the center of main interest, COMI, it is called COMI, of the proceedings. The presumption of registered office as COMI is considered. Also the main place of business to be considered. It is suggested that main and non-main, this will be considered based on the registered office of the corporate debtor or the main place of business of the corporator, from which this insolvency proceedings has emerged. If it is emerged from this country, India, that proceedings will be considered as the main proceedings. If it is emerged or appear from the proceedings of the other country, that proceedings will be considered the main proceedings. And other proceedings, all other proceedings will be considered as non-main proceedings. So the center of main interest, to find out the center of main interest is also another very, very important point for cross-border insolvency proceedings. It is suggested that foreign representative must be given access to the insolvency system and infrastructure in India for the purpose of cross-border insolvency proceedings. They said that government has to, or the code or the legislation must provide the access to the foreign representative to the insolvency system and infrastructure in India. It is noted no distinction should be made between foreign representative and regulated by professional regulators or not. Yeah, good. There is another issue. You know what's happened? Generally, we IPs are regulated firstly through our IPS, and then the main regulator is IBBI. But this foreign representative, they are not regulated. They will not be regulated by IP or IBBI. But this CBIRC, they have suggested that even then the foreign representative must give access to the insolvency system and infrastructure in India, though they are not regulated. They are not the regulated person, but in order to have a successful cross-border insolvency procedure, they have to give access. You cannot say that, look, since they are not regulated, or let the IP or IBBI, I don't know. I mean, very difficult to comment at this place unless the detailed procedure comes out. But it appears that they said that whether IPA or IBBI regulates them or not, they have to give access to the proceedings. No distinction can be made for them. It is noted that neither the code nor the IP regulations restrict Indian IP from applying for accessing insolvency system of a foreign jurisdiction. Okay, they said that it is since it is not applicable for Indian IPs, because neither the code nor the regulations framed for this purpose restrict Indian IPs from applying for necessary insolvency system as accessing the insolvency of foreign jurisdiction. Whether the permission will be granted or not, that is different thing, but they can apply. Okay. I think I am clear what I am saying. It is suggested that central government should frame guidelines for communication between NCLT and foreign courts. They said proper, I mean, definitely either it should be in the code itself or through rules or through regulations, but the proper guidelines should be there for communication between NCLT and the foreign courts. The NCLT may adopt the guidelines framed by the central government on a case-to-case basis with such modifications as it may deem fit in the context of a given case. So what they suggest, because you know, it is said that for domestic insolvency also, that IBC is an evolving procedure or evolving law. What does it mean? Because when many things, you will appreciate that many things is now settled out of jurisprudence. Maybe it is not very categorically mentioned in the code itself or in the rules or in the regulation, but through jurisprudence, it is now is as good as a settled law. Generally, I mean, we operate in that way only, that what is settled in the either NCLT or NCLAT or through Supreme Court. So here also suggestion is that they let the central government frame the guidelines for the communication between NCLT and foreign courts, but they say the NCLT may adopt this as a guideline, and they are free to modify this on a case-to-case basis as it required for a particular proceeding. It is not a, it should not be stringent guidelines. It should be a flexible guidelines based on the proceedings. Okay. It is suggested that for the protocol of cooperation between domestic IP and the foreign representative for a case, the scope of such protocols will vary from case to case depending on the nature and complexity of the case, which will be decided by the domestic IP and the foreign representative. Again, they say they have suggested for a flexible protocol of cooperation between domestic IP and foreign representative. They said it should be on a case-to-case basis. There should not be a rigid one, because this protocol, this communication or cooperation, it varies from this communication or protocols. It varies from case-to-case basis. If you have a rigid one, then maybe it will not work. So they said it will be decided by the Indian IP on the foreign representative. Exactly this order was passed by NCLAT in Jetiwari's case. We will discuss that. Need for infrastructure and designated bench for adjudication of cross-border insolvency cases. So now the CBIRC said that if we have a proper cross-border insolvency proceedings, we must have proper infrastructure and we must designate the benches for such adjudication. The infrastructure which presently our adjudicating authority has, they said it requires some, what should I say? They said that it requires the appropriateness. They said that the infrastructure for addressing the domestic insolvency and cross-border insolvency obviously not equal, and they said that there is a need for the proper infrastructure for the adjudicating authorities. So what do they say for designated bench? CBIRC suggested that all benches of NCLT should be vested with the jurisdiction to deal with the cross-border insolvency proceedings. They said, irrespective of the location of the bench, all bench should be empowered to adjudicate the cross-border insolvency proceedings, like your domestic insolvency proceedings. There should not be any earmarked that, look, this bench only will be authorized to adjudicate the cross-border insolvency. The proceedings arising in respect of corporate debtor that are Indian entity will be dealt with at the branch having jurisdiction over the location of the registered office of the corporate debtor. You are aware that presently also for the domestic insolvency proceedings, the bench of NCLT is considered where the registered office of the corporate debtor is situated. Similarly, they said for the Indian company undergoing cross-border insolvency, in their case also, the criteria for allocating the adjudicating authority or allocating the bench should be where the registered office of the corporate debtor is situated. Insolvency proceedings pertaining to any person incorporated with limited liability outside India should be dealt with by the principal bench of NCLT, New Delhi. But only exception, they said that, look, the registered office criteria will be applicable or may be followed for the Indian companies. But for the companies or LLP, limited liability entity, incorporated outside India, that is a foreign one, the designated bench should be the principal bench of NCLT, which is located in New Delhi. So only principal bench New Delhi will adjudicate the cross-border insolvency proceedings for the foreign companies in our country. Am I clear? Please ask me the question if you have anything, any doubt. CBIRC said about capacity consideration that the adjudication of cross-border insolvency issues is not any more complex than the overall complexity involved in domestic insolvency cases. So it would be desirable for all the benches of NCLT to develop and augment expertise to handle such matters. They said, look, I mean, this cross-border insolvency, the complexity which is involved for the cross-border insolvency is not a great extent different from the complexity which we already face or the adjudicator already face in India. Maybe the assets are located in different locations, but the complexity of the proceedings are the same. So they recommended all benches of NCLT should be developed and the proper expertise should be, I mean, augment means developed to handle the cross-border insolvency matters also for related to the companies incorporated in India. It is felt that developing bench-specific expertise in cross-border matter might not be efficient as members are transferred from bench to bench. Friends, you know, sorry. You know that the judges, the members of the NCLT, their job is transferable job. So they are prone to transfer from one bench to another bench. So CBIRC said that if we develop a particular bench, say Mumbai bench, for the cross-border insolvency, in case of transfer of the member or judge, it will create a problem. You can understand this thing. No? So because of this they said that for this purpose, that such expertise should be developed for all benches. It is therefore suggested that all benches of NCLT should be vested with the jurisdiction to deal with cross-border insolvency process applications in respect of corporate debtor whose registered office is located within their territorial jurisdiction. Clear? This is only for the Indian company. I mean, companies who are incorporated and having registered office in India. All cases in respect of Indian companies under IBC, including the cross-border proceedings arising in such cases, will continue to be dealt with at the bench having jurisdiction as per registered office. They said all bench should have the equal, should be developed equally to handle the cross-border insolvency, and the bench in respect of the registered office of the corporate debtor should adjudicate the cross-border insolvency proceedings. So this will be based on the registered office. However, cases pertaining to foreign companies could be dealt with by the designated bench, principal bench, by a designated bench, principal bench of NCLT, New Delhi. And the reason, what reason they have given, I am about to tell you, but I said that I found that it is also mentioned here. As the foreign companies in India are required to be registered with the Register of Companies New Delhi. This is as per the provisions of the Companies Act. So foreign companies, while the Indian companies can be registered with the registered office across the country, but as per the Companies Act, the foreign companies are only registered with the Register of Companies New Delhi, are required to be registered with the Register of Companies New Delhi. So CBIRC said that since this provision is already there, so let the cross-border insolvency for the foreign companies be adjudicated through a designated bench, which is the principal bench of NCLT in New Delhi. So this they have told about the designated bench. CBIRC felt that otherwise designated specific bench for cross-border proceedings may lead to complications in the management of cases with cross-border implications. The cases may be transferred midway when the cross-border element arises in the local IBC proceedings. So they have given another justification for this purpose. They said, look, if we don't develop all the benches and advise the bench in which the registered office, in which territory the registered office of the corporator is situated, then what problem may come? You know, suppose one Indian debtor goes into corporate insolvency procedures. So what's happened? When the Indian creditor files the application, they file the application either under Section 7 or Section 9 with the NCLT where the registered office is situated. Now, after some time, if a cross-border proceedings also arise for that corporate debtor, which is not known at the time of filing the application, then what happens? If there is a designated bench for adjudicating the corporate cross-border insolvency, then we have to transfer the entire thing to that designated bench, and this will really affect the continuity of the case. Many, I think all of you are aware that many things are decided, or the judges are made up their mind or form their opinion based on the hearings conducted during the course of exchange of arguments, during the course of arguments. So if it is so, then many things will be not all are recorded. They hurry, they form their opinion accordingly. So if it is transferred subsequently, so many things may be lost. So it will really seriously affect the proceedings, lead to complications in management of the case, because subsequently some cross-border element has come and you have to transfer the case. This will also disrupt the existing rule on vesting jurisdiction in the bench of the NCLT having territorial jurisdiction as per the corporate debtors registered office location. I've already discussed this. So mainly they said that, look, first of all, the complexity of the cross-border insolvency and the domestic are not very great. So all the benches of NCLT has the expertise to conduct the proceedings of the insolvency resolution process, number one. And secondly, they said if there is any designated bench and if in the midway the case is to be transferred to the other bench because of the specific designation, this may affect the management of the resolution process. So for these two reasons, they said that for the Indian company incorporated in India, having registered office in India, it should be dealt with the NCLT in which jurisdiction the registered office of the company is situated. But for the foreign company, they said, since there is a provision in the Companies Act that all the foreign companies should be registered with the register of our companies New Delhi, so the principal bench NCLT New Delhi should be considered as the designated bench to adjudicate the cross-border insolvency. Hello, any question? Any question you have? CBIRC has provided the following illustration of the suggested approach. Suppose the corporate debtor is X, a domestic IBC case in respect of X will proceed entirely. May I request all of you kindly switch off? Or if you have any question, please ask the question. You can open your mic and ask the question. Otherwise, kindly switch off your mic. Hello. I think Mr. Vikas Gera. Can you please switch off yourself? Mr. Gera, kindly switch off your mic.
चार्ज देना है इनको और आउटलुक है आउटलुक के बाद चार्ज की है ना उसमें
Any administrator is here from ICSI. Kindly switch off all the participants' mic.
Moderator, please request you to kindly mic, turn on the mic, turn off that mic. It's disturbing the faculty.
Otherwise, very disturbing. I mean,
कोई नहीं फाइनल करके दे देंगे ठीक है ठीक है ठीक है
suppose the corporate debtor is X, a domestic IBC case in respect of X will proceed entirely at the bench having jurisdiction at the location of the registered office of X. An application for the recognition of a foreign insolvency proceedings in respect of X will also be filed at the same bench as per CBIRC's suggestion. So if any insolvency proceeding is going on, it will be based on the registered office, and subsequently if any recognition of foreign insolvency proceedings reveals or comes into picture, it should be filed with the same bench. And in the second scenario, they said that suppose X is the foreign company with operation in India, an application for the recognition of foreign insolvency proceedings in respect of X would be filed at the principal bench and designated. So I think these explanations or illustrations are very much clear, what we have discussed so far. The advantage of this approach is that there is utmost certainty about the place at which the entire resolution and entire insolvency proceeding in respect of an Indian company and a foreign company in India will take place. There will be no disruption in the existing register office-based jurisdiction rule under IBC. This will not overburden one single bench with all potential insolvency cases with cross-border implications. This requires that the infrastructure, training, technical capacity of NCLT will require to be augmented across all benches to enable the members to deal with cross-border applications. So these are the reasons they have also mentioned in their suggestion why they are in favor of. No, they are not in favor of having any designated bench for the cross-border insolvency proceedings for the Indian companies, and why they are in favor of having a designated case for the foreign companies. Then they also suggested for the capacity building and infrastructure requirements. It is said that many Indian companies currently having global presence. Similarly, many foreign companies are in India. Yes. Therefore, an effective cross-border insolvency framework has become a must to have for India. However, for legislative framework to deliver solutions to cross-border insolvency proceedings, there should be human and organizational capacity and physical infrastructure to support the legislative framework. So, I mean, all of you know that when we file an application, how it is to be filed, how the numbering is done, how the cases are listed in the cause list. So,
Yes, sir.
so this all requires the human involvement for the proceedings. Similarly, for when the cross-border insolvency will come into place, they said that proper development of framework, both human and organizational capacity, and also the physical infrastructure, size of the courtroom. I don't know, I mean, this all will be revealed when the proper act will come. So, but they said that the size of the infrastructure to support the legislative infrastructure should also be developed or improved, they said. The capacity building needs to take place in all benches of NCLT, absolutely right. No need to elaborate. As on the date, it is difficult to anticipate the case volumes of this is very important. When as on the date, it is difficult to anticipate the case volumes NCLT will have under the cross-border framework. The sources indicate significant foreign exposure of Indian companies. The exposure are in form of foreign assets or operation and foreign liabilities. Similarly, as per MCA data, there are significant number of non-financial foreign companies in India. Very, very, what should I say, relevant, absolutely relevant, but also very important point to be considered for our legislature to frame the legal framework. And that's why they said that the proper infrastructure support to be developed. Because at present, it is very difficult to ascertain the volume when it will be open. When our code will also equally capable to address the cross-border insolvencies cases. So at that time, it will be very difficult to access, determine the volume which NCLT will have to be have to handle. Therefore, NCLT needs to undertake an adjusted expansion of its bench strength to meet the case flow arising from cross-border insolvency, both Indian and foreign companies. Depending upon the flow of cases, the bench capacity augmentation in NCLAT may be necessary, including inter alia the capacity of registry of both NCLT and NCLAT. So this CBIRC said that it is not applicable for NCLT. Similar requirement or capacity augmentation is required for the office of NCLAT also. Maybe, I don't know. Presently, we have two, benches for NCLAT. One is in Delhi and another in Chennai. Nobody can anticipate, nobody can predict whether this will be sufficient. And similarly, the registry of NCLAT and NCLT, if there are more benches are required, definitely the more registry to be developed should come into place. CBIRC suggested that NCLT has to consider the expansion of physical and technological infrastructure, namely e-filing of applications and documents for cross-border proceedings. Presently, we are making the e-filing of our applications. So for cross-border also, the foreign company will e-file their applications. Whether the present portal or present system, website of NCLT and NCLAT is sufficient to handle that foreign filing, that has to be determined, that has to be explored. Electronic access to records and court proceedings for foreign representatives. All this cause list, order, everything, it should be accessible to the foreign representatives. Presently, we are doing within the country. But when cross-border insolvency will come, it has to be handled by the foreign representative. Facility for electronic hearings for foreign representative and other foreign parties, and facilities to enable court-to-court communication and cooperation, and to hold joint hearings. It is also a very, very important point, joint hearing. How to handle the joint hearings of Indian court and foreign court. Suppose one particular issue for which hearing is going on in Indian court also have the similar or maybe the equal impact on that foreign proceeding. So how it is possible to have a joint hearing procedure in these cases? That has to be explored in order to have a very successful cross-border insolvency resolution process. Here I must say, I don't know the situation in other benches, but electronic hearings here in our Kolkata bench, it has really improved a lot. Now we have a very good electronic hearing system.
The same goes with Mumbai bench.
Mumbai also, no? I think so.
Yeah, Mumbai also it is very good.
Achha. Now earlier it was not so good in India, in Calcutta. Very difficult. The voice is not, And we used to go to, I mean, visit that NCLT hearing.
Sir,
Personally.
Delhi is also hybrid. This is very nice.
Very nice. No? Yeah. Now they are looking for this, all these things.
Of
Because
course,
they have to
actually,
do, they have to do it.
they are providing the Wi-Fi free of cost now.
Acha? Good.
Yes. So at least you can physically, if you are going there, then you can use the Wi-Fi also.
Yeah, yes, yes. Similarly for Kolkata also. They are now providing free and very, very strong Wi-Fi.
Yes. So these are the now infrastructure is not a problem.
Improving, but you don't know when cross-border will come, how it will work. That's
So
what I'm saying.
many cross-border spending, group
प्रॉब्लम क्या
insolvency
है ना
pending.
ये लेजिस्लेशन आया वो तो पार्लियामेंट में पास कर देगा.
Correct.
Okay, this is passed. Now it is, rule is framed, regulation is made. But when actual things will come, how it will work, how it will operate, that the music we have to face, na? We
Sir,
are the have to face those music.
getting hearings for the case has become a Herculean task.
Absolutely. Absolutely.
Because when you are, the very difficult to for the hearing of resolution plans to be approved, it takes years after years.
I mean, getting next date within a month, I think you are lucky.
Yes, absolutely. And every NCLT is like that. It is not like that. Most of the NCLTs are like that. They are giving 30 days time the next date hearing.
And especially if you are a, sorry, I am, we are diverting from the discussion, but
Yes.
especially if you are the, I mean, handling a personal guarantor case.
Yes.
I have a very, very, I mean, what should I should say that sorry state of affairs.
Actually, yes. There is a larger issue. We have to, to see from the larger perspective. That means the appointment of the, I must say the technical members should be appointed by the CAs and CS or something like that. So that may be some improvement we can see.
That's true. I agree. I agree.
Anyway.
Okay, let's go back. Thank you. So once these capabilities are put in place, there will also be a need for undertake training programs for the NCLT and registry personnel in their use, and to create capacity to maintain. All these are suggestions. That's why I said it is to see that how government has considered these suggestions. But these are according to very, very valid and important suggestions they have made. Create capacity to maintain and troubleshoot these systems on an ongoing basis. CBIRC suggested to develop a standard operating instructions on how cross-border matter cases will move through NCLT system. Train NCLT registry staff, in dealing with the wide range of issues and challenges that will arise in respect of cross-border matters, and develop standard instructions on court-to-court communication and cooperation, and on holding joint meeting. They suggested for a SOP for this. And I think it is very, very, very well accepted suggestion. CBIRC opined that over the time, as more and more cases with cross-border implications come for adjudication, judicial familiarity with the international jurisprudence in respect of moral law and conflict of laws related to issues will get enhanced, and the system and processes for court-to-court cooperation and communication will get fine-tuned. So they said that this knowledge is required across the ecosystem. Not only the IPs will be familiar, everybody who are participating in this insolvency ecosystem, they should also be familiar, and vice versa also. The other side also know the provisions and the implications of the provisions of our code. CBIRC suggested that NCLT should develop a system of case numbering which will assign a unique identifier to every debtor company's insolvency proceedings, with the enabling identification of root main and root non-main proceedings where domestic and cross-border proceedings currently exist. I'm sure that you know that now. We have that the seriality by which we can track your application. Or you can mention in your hearing that this application is, hard at that time, that CPIB number, then the bench number, then the year of it. So they said that similar numbering system should also be chalked out so that the distinction can be made for the main item, because I said the main item will be whether the main place of business or the registered office, and non-main where other places will be considered non-main. And so whether this proceeding is a non-main item proceedings or main item proceeding, proper numbering should be developed. It can be seen or it can be known from the numbering system itself. Am I clear?
Yes, sir.
CBIRC suggested that IBBI will also need to increase its organizational and human framework. It is required to regulate IPs who will undertake foreign assignments as well as the foreign representatives. For that, they said that IBBI also has a role to play. IBBI may consider developing separate regulations in respect of insolvency proceedings for foreign companies. Definitely yes, because law committee, insolvency law committee has suggested for a separate part in the code. So definitely there should be a separate regulations for this cross-border insolvency process or for these foreign companies. IBBI may also consider for creating a central repository of case information of matters related to cross-border information in line with the system created for CIRP and liquidation proceedings. Separate system they have suggested to be made by IBBI for all these cross-border matters. So friend, I am through with my discussion. Now I have to discuss what is the time now. Two cases I have selected for the discussion. I told you that not very much jurisprudence. So here can we take 5 minutes break if you don't mind? Hello? Can we have
Yes,
5
sir.
minutes break here?
Yeah,
Yes,
yeah,
sir.
please.
Yeah,
please.
okay, sir.
Yes, sir, please.
So it is 5:15, I believe. We will come at 5:20. Okay.
Okay, sir.
Okay, sir.
Thank you so much. So can we start now? Friends, can we start now?
Yes, sir.
Yes, sir.
So it is visible now, my presentation? You can see
Yes,
my
sir.
huh? Okay.
Yes, sir.
Yes, sir, we can see.
Okay, thank you. So the first case law which I want to discuss with you is the State Bank of India versus Jet Airways India Limited. And according to me, it is the only case law till date which has the cross-border insolvency flavor. Another case law we have, but that has, I mean, we'll discuss that thing. Okay, we'll discuss thing, but till that, I believe it is the only case law which have the cross-border insolvency flavor, where both the Indian IP and the foreign representative, they work together to have the resolution process for the corporate data, Jet Airways. So Jet Airways India Limited, or in short, Jet Airways case is the first cross-border insolvency case in India. The order of NCLT Mumbai bench approving the resolution plan for the, another thing, friends, I want to say that, look, I am presenting a very abridged form of the order. I picked up from the order itself and I make my presentation. So I suggest all of you, you should once read this order in order to understand the entire, I mean, circumstances or scenarios which is handled in this case. Okay. The Jet Airways India Limited, Jet Airways case is the first resolution. The order of NCLT Mumbai bench approving the resolution plan for the revival of Jet Airways has marked the end of the first cross-border insolvency case determined under IBC 2016. So this has a successful resolution plan. However, the final determination by NCLT has brought the insights into the working of the code, as well as led its limitations for resolving cross-border insolvency proceedings. I have already mentioned that Insolvency Law Committee also referred this case. The resolution professional of India and the administrator appointed in Netherlands had to test several principles in absence of regulatory framework in India for dealing with cross-border insolvency cases. Seriously, in fact, this is done as a case-to-case basis. Because NCLT was very supportive for this. Liquidation proceedings was admitted against Jet Airways on May 21, 2019 by the Dutch Bankruptcy Court in Netherlands, and Dutch administrator was appointed to take charge of Jet Airways assets located therein. The same was done at the instance of a bankruptcy filed by two European creditors against Jet Airways. So this is filed in that foreign country, I mean jurisdiction, Netherlands. The European creditors were seeking the seizure of one of the Jet Airways Boeing 777 aircraft, which was parked in Amsterdam airport. So this corporate debtor, which has a registered office in India, main place of business is also in India, but they had an assets located in Amsterdam, in other country, beyond the territory of India. And what's happened? The foreign creditors, they seek to seize that aircraft and to pay their debt. And the order also passed, liquidation order also passed by the Netherlands jurisdiction. State Bank of India filed a Section 7 application before NCLT Mumbai against JTRS, upon admission of which on June 20, 2019, the corporate resolution proceedings of JTRS was started. Friend, here I really request you to note the date. The liquidation proceeding, Dutch bankruptcy court passed the order on May 21, 2019. And the admission of Section 7 application was made by the NCLT Mumbai on June 2019. So that is prior to this. So definitely is a cross-border insolvency situation. Upon admission of on which on June 2019, the corporate insolvency resolution proceedings of J2RS was started. Interim resolution professional was appointed and moratorium was imposed under Section 14 of IBC 2016. So what's happening? It is started here, moratorium also declared. Therefore, the Dutch administrator filed an intervention application, IA application. You know, when the main proceeding started, whatever applications are filed, it is marked as IA, intervention application. Before the NCLT Mumbai during the CIP proceedings to recognize the judgment of Dutch Insolvency Court. He said, look, this is the judgment already passed by the Dutch Insolvency Court. So he filed the application, intervention application before NCLT Mumbai and requested to take the cognizance of that order. It was requested before NCLT Mumbai to withhold the CIP on account of the ongoing bankruptcy proceedings against J2RS in the competent Dutch court. They said this should be withheld. It should not be ordered to continue that CIP in India because already there is an order passed by the Dutch competent Dutch court against this corporate debtor, which derived its jurisdiction under Dutch Bankruptcy Act. It was highlighted that occurrence of two parallel insolvency proceedings in different jurisdictions would adversely affect the restructuring process and have a detrimental impact on the creditors involved. So because of this reason, they say that you dismiss that proceeding or withhold that proceedings. Let it be first settled and then that will be started. NCLT Mumbai in this regard opined that as per sections 234 and 235 of IBC, for recognition, the orders of a foreign jurisdiction mandate the requirement of Indian government to have reciprocal arrangements with foreign country. NCLT noted that in the instant case, no reciprocal arrangements were made with Dutch authorities. So this is the observation made by NCLT Mumbai. There is no for recognition of the order as per section 234 and 235, a reciprocal arrangement should the Indian government have with that country, and there is no such arrangement. The primary issue was considered pertaining to the jurisdiction of the Dutch court to adjudicate upon and pass orders in the matter relating to the bankruptcy of J2RS, which is registered and incorporated in India. I have already mentioned this one. Incorporated and registered in India, but the proceedings has already been started there. NCLT Mumbai, vide it order dated June 20, 2019, set aside the proceedings of the Dutch court and declared it as a nullity in the eye of law. NCLT Mumbai categorically said, look, this order cannot be accepted It is a nullity in eye of law. It is a nullity as per the provisions of IBC 2016, since there is no reciprocal arrangement with Netherlands government. The order of NCLT Mumbai was challenged before NCLAT by the Dutch administrator as regard non-recognition of Dutch proceeding. Definitely, I mean, obviously they will challenge and they will file appeal before NCLAT. The NCLAT allowed the appeal and set aside. It is very important. This is the first time Indian court, they have really supported to have a fruitful, meaningful cross-border insolvency process in this country. NCLAT allowed the appeal and set aside the order passed by NCLT Mumbai upon an assurance being provided by the Dutch administrator that it would not alienate any offshore assets of J2Ls. Status quo maintained. So that assurance that administrator given, and this NCLAT set aside the order of Mumbai NCLT. It also directed the resolution professional to consider the feasibility of having a joint corporate insolvency resolution process. Mark this word. It is mentioned in the order of NCLAT that please find out a feasibility of having, find out the feasibility of a joint corporate insolvency resolution process in coordination with Dutch engineer, because NCLAT also indirectly admitted that there is no provision as such in the code. So it directed the Indian professional, resolution professional, to find out the feasibility of the corporate joint corporate insolvency process with Dutch administrator. The resolution professional along with Dutch administrator reached an agreement for facilitating the resolution process through a proposed cooperation model which was constructed on the basis of the principles provided in ancestral model law and submitted it to NCLAT for approval. So they have prepared a proposed cooperation model, and that also based on ancestral model law. This is very important because, you know, when we make the elaborated legal proceedings provisions for in our code, that also be in line with this model law. Otherwise, it will not get recognized by the other countries. So here both the person, they prepared this proposed cooperation model based on that model law and placed before NCLAT for its approval. NCLAT accepted the model and approved the same while its order dated September 26, 2019. So the NCLAT also provided acceptance or approval on this proposed cooperation model. NCLAT also allowed Dutch administrator to participate in the meetings of the Committee of Creditors. Only to the it is mentioned by the CBIRC, that how the recognition will be given for the foreign. So NCLAT already has done these things. It allowed the Dutch administrator to participate in the meetings of the Committee of Creditors only to the extent of observing and preventing any likely overlap of powers. But NCLAT allowed through its order. It was ordered for ensuring cooperation between resolution professional and Dutch administrator in order to finalize the resolution plan, which would be in the best interest of J2RS and all its stakeholders. The application for the approval of the resolution plan was filed before NCLT Mumbai. The NCLT Mumbai, by its order dated June 22, 2021, accepted the plan on a majority of points and gave time period of 90 days to the successful resolution applicant for taking necessary regulatory approvals and permission from DGCA, Director General of Civil Aviation. NCLT Mumbai also ordered for the formation of a monitoring committee for overseeing the entire process. Jet Airways case presents itself to be an interesting case study relevant to the legal position pertaining to cross-border insolvency proceedings in India. It is really a case study. This is how the Indian court really facilitated to have the cross-border insolvency in absence of proper provisions in the code. It highlights an earnest attempt by the Indian judiciary in evolving principles and effecting mechanisms to deal with cross-border insolvency proceedings. However, at the same time, the case study raised some key concerns regarding the inadequacy of the provisions of the code. Time and again, I am telling this thing. Current code, current IBC provision are not adequate to address the cross-border insolvency resolution process. So this is the, I mean, gist. I am maintaining that this is the very gist of the order given in State Bank of India Jet Airways Limited, and I really suggest all of you, please go through this order. The second case law which I have, it is Stanbic Bank Ghana Limited versus Messrs. Rajkumar Impex Private Limited. And it is passed by NCLT Chennai bench. I think it will, I will be able to answer the questions raised by Mr. Khatri by discussing this case law. If I can't, then I request him, you, Mr. Khatri, please raise this point during the question answer section. The fact is of this case is the, not fact, the, I mean the, what is the case deals with that the adjudicating authority, while admitting a Section 7 application filed on the basis of a foreign decree, had observed that authority does not have the jurisdiction to enforce such decree and only took cognizance of the same. Chennai bench NCLT categorically said, look, adjudicating authority doesn't have any jurisdiction to enforce the decree passed by the foreign court. But definitely you can take the cognizance of that decree in further proceedings. The said admission of NCLT Chennai bench was also upheld by NCLAT as well as the Supreme Court of India. So both the Apex Court, NCLAT and Apex Court, they upheld that order which was passed by NCLT Chennai here, Chennai bench here. Now comes to the brief fact. This is the brief fact of the case. Financial creditor Messrs. Stanbic Bank Ghana Limited had extended a loan to Messrs. Rajkumar Impex Ghana Limited, who is a principal borrower, a wholly owned subsidiary of Rajkumar, Messrs. Rajkumar Impex Private Limited, a guarantor, a company incorporated in India. It is a corporate guarantor. On default, the financial creditor initiated proceedings against principal borrower in Ghana and against guarantor before English court. So they have done both the things. They have raised the insolvency proceedings against that Rajkumar Impex Ghana Limited in Ghana court, and also they filed the proceedings against Rajkumar Impex Private Limited in English court. And this is done, I will come to this as per the agreement. While the proceedings before Ghana court was in process, it is still continuing. The English court passed an order against guarantor, Rajkumar Impex Private Limited, a company incorporated in India. On the basis of the said order, the financial creditor filed an application under Section 7 of the Code for initiation of CIRP of the guarantor. Based on the English court order, that Stanbic Bank Ghana Limited, they filed an application. While admitting the application, the adjudicating authority held that as the petitioner has made out a prima facie, petitioner here, that Stanbic Bank, has made out a prima facie case and also proved that there is debt due payable by the principal borrower, and there is decree made against the respondent, that is guarantor. This tribunal has no jurisdiction to enforce the foreign decree. However, there is no bar in taking cognizance of the foreign decree. So this is the fact of the case. Now, during hearing, what contentions the petitioner counsel took. The learned counsel for the petitioner submitted that Messrs. Rajkumar Impacts Ghana Limited, insured the principal borrower, is a subsidiary of the respondent, that is Rajkumar Impacts Private Limited, herein, and has borrowed money to the tune of US dollar blah 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 from the petitioner financial creditor and has failed to repay the said amount as per the terms and conditions of the loan agreements. Since the principal borrower has failed to repay the loan amount, the petitioner financial creditor filed a suit before the Ghana court, which is pending for disposal. The respondent herein is a guarantor to said loan amount by way of a deed of indemnity and guarantee with the petitioner financial creditor, in which the respondent assured the petitioner financial creditor that respondent would repay the amount borrowed on failure of the same by the principal borrower and also would indemnify the petitioner financial creditor. So this is the contention of the petitioner. They also said that since the principal borrower failed to repay the loan amount, the petitioner financial creditor initiated proceedings before the Honorable High Court of Justice, Queen's Bench Division, Commercial Court, London, against the respondent as per the provisions of deed of indemnity and guarantee, wherein the parties agreed that governing law would be English law and the courts of England and Wales have the exclusive jurisdiction. So, though they have filed the insolvency proceedings against that principal borrower in a Ghana court, but for this respondent or guarantor, they filed the court in the Queen's Bench Division, Commercial Court, London. The said Honorable Court, after giving sufficient opportunity to the respondent, made an order dated, the date I have not mentioned, and a decree was passed in favor of the petitioner financial creditor for a sum of, US dollar something, comprising the principal amount and the interest thereof. Since this respondent, who is the guarantor herein, did not repay the amount as per the order of the said Honorable Court, the present petition is filed before this tribunal, that is NCLT Chennai, on the basis of the said decree, with prayer to admit the petition and to initiate corporate insolvency resolution process against the respondent under Insolvency Bankruptcy Code 2016. So friend, this is the contention made by the counsel of the petitioner or financial creditor. The contentions of the respondent, that is Rajkumar Impacts Private Limited, the learned counsel for the respondent filed a counter and vehemently argued that the petition under IB Code 2016 is not maintainable on the ground that petitioner financial creditor, not being an Indian company within the meaning of Companies Act, cannot invoke the provision of IB Code and prefer a petition styling themselves to be a financial creditor. So they challenge the application. They said there is no such provisions because it is an foreign company and there is no provision they can file. Application. Foreign creditors can file claim, but application there is no provision. The observations and order of NCLAT Chennai bench. Taking into consideration the submissions made by both the parties, the issue that arises before the adjudicating authority is whether the petitioner financial creditor has made out a prima facie case under Insolvency and Bankruptcy Code 2016 for the purpose of initiating corporate insolvency resolution process against the respondent who is the guarantor for the principal borrower or not. The AA observed that it is on record that the petitioner financial creditor initiated proceedings against the respondent guarantor before Honorable High Court of Justice, Queen's Bench Division, Commercial Court, London, and it has passed a decree in this respect, and it is contended by the respondent that the order made by the said Commercial Court, London, is not conclusive, and it is also not on merit. On perusal of the said order, the AA observed that it is recorded by the Honorable Judge of the Queen's Bench that there was an order for serving the notice to the defendant, that is respondent hearing, and it is also recorded that proceedings were duly served to the defendant. However, the defendant did not thereafter file any acknowledgement of service or defense or any other document in relation to the proceedings. Thereafter, the application was filed, and it is also recorded that application was also duly served to the defendant, and the date of hearing was also informed to the defendant. It is also recorded in the order that the defendant has neither appeared nor represented, although it has given every opportunity to do so. Subsequently, Honorable Judge of Queen's Bench has also recorded that he turned to merits of the application. The point now raised by the respondent that the order of the London Court is not made on merit is not supported by any law, and therefore respondent is stopped from making such plea before this adjudicating authority. This NCLT Chennai in his order categorically mentioned the circumstances under which the Queen's Bench order was made, and said that at this point of time, because they have given respondent, that is Rajkumar Impas, was given ample time to represent themselves before that Honorable Queen's Bench, but they didn't. So at this time, they cannot raise this point. In view of all the submissions made by the parties and the observations made, the AA concluded that the petitioner financial creditor has made out a prima facie case under IB Code 2016. They have a case because there is a decree. A admitted the petition as the petitioner has made out a prima facie case and also proved that there is a debt due payable by the principal borrower, and there is a decree made against the respondent guarantor. However, this is very important, friend. I really request you kindly see these things very carefully. However, it is mentioned in the said order that the AA has no jurisdiction to enforce the foreign decree. It is categorically NCLT Chennai says, I don't have a jurisdiction to enforce the foreign decree. But there is no bar in it taking cognizance of the foreign decree, as the English Commercial Court is recognized under Section 13 of, I already said that it is come under Section 13 of and 44A of CPC. So they can take the cognizance of the order. Then the order also, I mean, defines certain reciprocating territory, means all these things, superior courts. I am not going through all these details. Decree, what is also meant by decree, they have mentioned these things. The net, what's happened, the objections raised by the counsel for the respondent are not valid ground for rejection of the instant petition. Therefore, petition stands admitted. And I said that till now what's happened, court generally handle this cross-border insolvency within the provisions of the domestic insolvency. The A thus ordered for the commencement of the corporate insolvency resolution process, which shall ordinarily get completed within 180 days, reckoning from the day of order passed. So they said that, okay, a corporate insolvency resolution process will be started based on the domestic insolvency provisions. So you know what's happened, this order of NCLT was challenged before NCLAT. An appeal was filed before the Honorable NCLAT against the order passed by the Honorable NCLT, Chennai bench, wherein it was contended that adequate proof of default had not been adduced by the financial creditor, and its application was based upon ex parte decree passed by the High Court of Justice, Queen's Bench Division Commercial Court, which ought not have been allowed by the Honorable NCLT. Dismissing such appeal, the Honorable NCLAT held as follows. This I have taken from the order. It was further submitted that the document relied upon by first respondent, that is a foreign decree of the High Court of Justice, Queen's Bench Division Commercial Court, which is an ex parte decree. Respondent here, that Stanbic Ghana. So they said that it was further submitted that the document relied upon is a foreign decree, and it is an ex parte decree. The said decree cannot be treated as to be a recorded default. It is only a declaration entitling the applicant to a certain sum of money. However, we are not inclined to accept the aforesaid submission as a record of decree is a proof of debt, and the record of default is required to be enclosed separately to suggest that no payment has been made in terms of decree. Those categorically said, look, this decree is sufficient for the NCLT Chennai to pass the order for CIRP. Admittedly, Mr. Rajkumar Impes Ghana Limited, a subsidiary of the corporate debtor, was granted medium-term loan by the first respondent. It is also not in dispute that Messrs. Rajkumar Impex Private Limited corporate debtor, which is the holding company of Messrs. Rajkumar Impex Ghana Limited, has executed a guarantee in favor of the Stanbic Ghana Limited. The guarantee given by the corporate debtor is on record. The decree passed by the High Court is an evidence in support of such guarantee. As admittedly the debt amount has not been paid by the corporate debtor, the adjudicating authority rightly admitted the application. The aforementioned judgment of the Honorable NCLAT was also upheld by the Honorable Supreme Court of India. So, friend, this is the case law for Stanbic Ghana Limited. I just want to inquire from Mr. Khachi. Mr. Khachi, just tell me whether you got your answer through this case law, or if you require any clarification, you may ask me. Mr. Khachi, are you there?
Yes, sir.
Yeah. I think he's there.
Can we conclude, sir?
Yes, just, Anjali, I'm more or less true. I'm more or less true. Just a minute. Yes, I'm through already. Next is the group insolvency. I think you have the separate session tomorrow for this. But only one thing I want to say that, look, this is group insolvency is also a future of insolvency. Many Indian companies have the group companies in abroad. But unless and until you have the provisions for the cross-border insolvency procedure, according to me, the group insolvency will not be a successful one. Either you have to have the provisions for cross-border insolvency first in place, then you make the provisions for group insolvencies, or both the insolvency procedures can be made parallel. I think better option should be, it should be done parallel. Because there are certain issues which will give rise to the group insolvency procedures, which may affect the cross-border insolvency procedures. So I am through. If you don't have any question, I stop my sharing. Okay. So I thank all of you for your patient hearing. And I really honestly believe that what I have discussed, it is understandable to all of you. And if you don't have any question, we can conclude our proceeding. We can conclude our session.
You can ask questions if you have any.
What is the time? Okay, just we have. I think we have 3 minutes more. Okay. Sanjali, what will do?
Then I think there are no questions. So can we conclude now?
Your voice is breaking.
Can we conclude now if there are no questions?
आउट आने वाला होगा ना
Sir, can we conclude now?
Yeah, we can conclude, Anjali. I am through with my presentation. So if there is no
Okay,
question,
thank you very much, sir.
we can conclude it. Okay.
Thank you, sir,
Thanks,
for
sir.
such a
Thank
nice
you, sir.
session, for sharing your knowledge with us. Sir, you are requested to share the PPT of the session.
So can I leave now?
Yes, sir. Yes, sir.
Hello?
Hello.
Hello, your voice is breaking. I cannot hear you. Hello? Anything more you have?
Sir, am I audible now?
Yes, you are audible now.
Thank you very much, sir, for a nice presentation.
Thank
Sir,
you.
please share your PPT referred within the session.
Yeah, sure. I'll do that.
I hope PPT will be getting.
Yeah, sure. I'll share it with the IPP, and you definitely they will.
Very nice. Thank you very much, sir. It was
Thank you.
nice.
Thanks. Thank you so much.
Many thanks, sir. It was indeed a very wonderful session, sir. And we have
Thank
got inside knowledge of this, cross-border insolvency resolution. So many thanks, sir.
Thank you so much. Thank you. Thank you for your, patient sharing. And if you have any question, you can ask me. Subsequently. Okay. So I close my, I leave the meeting now. Okay.